This audio case is brought to you by Laudio. United States versus Lopez. Supreme Court of the United States. Decided April 26, 1995. Chief Justice Rehnquist delivered the opinion of the court. In the Gun-Free School Zones Act of 1990, Congress made it a federal offense for any individual knowingly to possess a firearm at a place that the individual knows or has a reasonable cause to believe is a school zone. The act neither regulates a commercial activity nor contains a requirement that the possession be connected in any way to interstate commerce. We hold that the act exceeds the authority of Congress to regulate commerce among the several states. On March 10, 1992, respondent, who was then a 12th grade student, arrived at Edison High School in San Antonio, Texas, carrying a concealed .38 caliber handgun and 5 bullets. Acting upon an anonymous tip, school authorities confronted respondent, who admitted that he was carrying the weapon. He was arrested and charged under Texas law with firearm possession on school premises. The next day, the state charges were dismissed after federal agents charged respondent by complaint with violating the Gun-Free School Zones Act of 1990. A federal grand jury indicted respondent on one count of knowing possession of a firearm at a school zone in violation of Section 922G. Respondent moved to dismiss his federal indictment on the ground that Section 922G is unconstitutional, as it is beyond the power of Congress to legislate control over our public schools. The district court denied the motion, concluding that Section 922G is a constitutional exercise of Congress's well-defined power to regulate activities in and affecting commerce, and the business of elementary, middle, and high schools affects interstate commerce. Respondent waived his right to a jury trial. The district court conducted a bench trial, found him guilty of violating Section 922G, and sentenced him to 6 months imprisonment and 2 years supervised release. On appeal, respondent challenged his conviction based on his claim that Section 922G exceeded Congress's power to legislate under the Commerce Clause. The Court of Appeals for the Fifth Circuit agreed and reversed respondent's conviction. It held that, in light of what it characterized as insufficient congressional findings and legislative history, Section 922G, in the full reach of its terms, is invalid as beyond the power of Congress under the Commerce Clause. Because of the importance of the issue, we granted certiorari and we now affirm. We start with first principles. The Constitution creates a federal government of enumerated powers. As James Madison wrote, the powers delegated by the proposed Constitution to the federal government are few and defined. Those which are to remain in the state governments are numerous and indefinite. This constitutionally mandated division of authority was adopted by the framers to ensure protection of our fundamental liberties. Just as the separation and independence of the coordinate branches of the federal government serve to prevent the accumulation of excessive power in any one branch, a healthy balance of power between the states and the federal government will reduce the risk of tyranny and abuse from either front. The Constitution delegates to Congress the power to regulate commerce with foreign nations and among the several states and with the Indian tribes. The Court, through Chief Justice Marshall, first defined the nature of Congress's commerce power in Gibbons v. Ogden. Commerce undoubtedly is traffic, but it is something more. It is intercourse. It describes the commercial intercourse between nations and parts of nations in all its branches and is regulated by prescribing rules for carrying on that intercourse. The commerce power is the power to regulate, that is, to prescribe the rule by which commerce is to be governed. This power, like all others vested in Congress, is complete in itself, may be exercised to its utmost extent, and acknowledges no limitation, other than are prescribed in the Constitution. The Gibbons Court, however, acknowledged that limitations on the commerce power are inherent in the very language of the Commerce Clause. It is not intended to say that these words comprehend that commerce, which is completely internal, which is carried on between man and a state, or between different parts of the same state, and which does not extend to or affect other states. Such a power would be inconvenient and is certainly unnecessary. Comprehensive as the word among us is, it may very properly be restricted to that commerce which concerns more states than one. The enumeration presupposes something not enumerated, and that something, if we regard the language or the subject of the sentence, must be the exclusively internal commerce of a state. For nearly a century thereafter, the Court's Commerce Clause decisions dealt but rarely with the extent of Congress's power, and almost entirely with the Commerce Clause as a limit on state legislation that discriminated against interstate commerce. Under this line of precedent, the Court held that certain categories of activity such as production, manufacturing, and mining were within the province of state governments and thus were beyond the power of Congress under the Commerce Clause. In 1887, Congress enacted the Interstate Commerce Act, and in 1890, Congress enacted the Sherman Antitrust Act, as amended. These laws ushered in a new era of federal regulation under the commerce power. When cases involving these laws first reached this court, we imported from our negative Commerce Clause cases the approach that Congress could not regulate activities such as production, manufacturing, and mining. Simultaneously, however, the court held that where the interstate and intrastate aspects of commerce were so commingled together that full regulation of interstate commerce required incidental regulation of intrastate commerce, the Commerce Clause authorized such regulation. In ALA Schechter Poultry Corporation versus United States, the court struck down regulations that fixed the hours and wages of individuals employed by an intrastate business because the activity being regulated related to interstate commerce only indirectly. In doing so, the court characterized the distinction between direct and indirect effects of intrastate transactions upon interstate commerce as a fundamental one, essential to the maintenance of our constitutional system. Activities that affected interstate commerce directly were within Congress's power. Activities that affected interstate commerce indirectly were beyond Congress's reach. The justification for this formal distinction was rooted in the fear that otherwise there would be virtually no limit to the federal power, and for all practical purposes, we should have a completely centralized government. 2 years later, in the watershed case of NLRB versus Jones and Laughlin Steel Corporation, the court upheld the National Labor Relations Act against a Commerce Clause challenge, and in the process departed from the distinction between direct and indirect effects on interstate commerce. The court held that intrastate activities that have such a close and substantial relation to interstate commerce that their control is essential or appropriate to protect that commerce from burdens and obstructions are within Congress's power to regulate. In United States v. Darby, the court upheld the Fair Labor Standards Act, stating, "The power of Congress over interstate commerce is not confined to the regulation of commerce among the states. It extends to those activities intrastate which so affect interstate commerce or the exercise of the power of Congress over it as to make regulation of them appropriate means to the attainment of a legitimate end, the exercise of the granted power of Congress to regulate interstate commerce." In Wickard v. Filburn, the court upheld the application of amendments to the Agricultural Adjustment Act of 1938 to the production and consumption of homegrown wheat. The Wickard court explicitly rejected earlier distinctions between direct and indirect effects on interstate commerce, stating, "Even if appellee's activity be local, and though it may not be regarded as commerce, it may still, whatever its nature, be reached by Congress if it exerts a substantial economic effect on interstate commerce, and this irrespective of whether such effect is what might at some earlier time have been defined as direct or indirect." The Wickard court emphasized that although Filburn's own contribution to the demand for wheat may have been trivial by itself, that was not enough to remove him from the scope of federal regulation, where, as here, his contribution, taken together with that of many others similarly situated, is far from trivial. Jones and Laughlin Steele, Darby, and Wickard ushered in an era of Commerce Clause jurisprudence that greatly expanded the previously defined authority of Congress under that clause. In part, this was a recognition of the great changes that had occurred in the way business was carried on in this country. Enterprises that had once been local, or at most regional in nature, had become national in scope. But the doctrinal change also reflected a view that earlier Commerce Clause cases artificially had constrained the authority of Congress to regulate interstate commerce. But even these modern-era precedents, which have expanded congressional power under the Commerce Clause, confirm that this power is subject to outer limits. In Jones and Laughlin Steele, the court warned that the scope of the interstate commerce power must be considered in the light of our dual system of government and may not be extended so as to embrace effects upon interstate commerce so indirect and remote that to embrace them, in view of our complex society, would effectually obliterate the distinction between what is national and what is local, and create a completely centralized government. Since that time, the court has heeded that warning and undertaken to decide whether a rational basis existed for concluding that a regulated activity sufficiently affected interstate commerce. Similarly, in Maryland v. Wirtz, the court reaffirmed that the power to regulate commerce, though broad indeed, has limits, and that the court has ample power to enforce. In response to the dissent's warnings that the court was powerless to enforce the limitations on Congress's commerce powers because all activities affecting commerce, even in the minutest degree, Wickard, may be regulated and controlled by Congress, the Wirtz court replied that the dissent had misread precedent, as neither here nor in Wickard has the court declared that Congress may use a relatively trivial impact on commerce as an excuse for broad general regulation of state or private activities. Rather, the court has said only that where a general regulatory statute bears a substantial relation to commerce, the de minimis character of individual instances arising under that statute is of no consequence. Consistent with this structure, we have identified three broad categories of activity that Congress may regulate under its Commerce Clause. Second, Congress is empowered to regulate and protect the instrumentalities of interstate commerce, or persons or things in interstate commerce, even though the threat may come only from intrastate activities. Finally, Congress's commerce authority includes the power to regulate those activities having a substantial relation to interstate commerce. Within this final category, admittedly, our case law has not been clear whether an activity must affect or substantially affect interstate commerce in order to be within Congress's power to regulate it under the Commerce Clause. We conclude, consistent with the great weight of our case law, that the proper test requires an analysis of whether the regulated activity substantially affects interstate commerce. We now turn to consider the power of Congress in the light of this framework to enact Section 922G. The first two categories of authority may be quickly disposed of. Section 922G is not a regulation of the use of the channels of interstate commerce, nor is it an attempt to prohibit the interstate transportation of a commodity through the channels of commerce, nor can Section 922G be justified as a regulation by which Congress has sought to protect an instrumentality of interstate commerce or a thing in interstate commerce. Thus, if Section 922G is to be sustained, it must be under the third category as a regulation of an activity that substantially affects interstate commerce. First, we have upheld a wide variety of congressional acts regulating interstate economic activity where we have concluded that the activity substantially affected interstate commerce. Examples include the regulation of intrastate coal mining, intrastate extortion and credit transactions, restaurants utilizing substantial interstate supplies, inns and hotels catering to interstate guests, and production and consumption of homegrown wheat. These examples are by no means exhaustive, but the pattern is clear. Where economic activity substantially affects interstate commerce, legislation regulating that activity will be sustained. Even Wickard, which is perhaps the most far-reaching example of Commerce Clause authority over interstate activity, involved economic activity in a way that the possession of a gun in a school zone does not. Roscoe Filburn operated a small farm in Ohio, on which, in the year involved, he raised 23 acres of wheat. It was his practice to sow winter wheat in the fall, and after harvesting it in July to sell a portion of the crop, to feed part of it to poultry and livestock on the farm, to use some in making flour for home consumption, and to keep the remainder for seeding future crops. The Secretary of Agriculture assessed a penalty against him under the Agricultural Adjustment Act of 1938 because he harvested about 12 acres more wheat than his allotment under the act permitted. The act was designed to regulate the volume of wheat moving in interstate and foreign commerce in order to avoid surpluses and shortages and concomitant fluctuation in wheat prices, which had previously obtained. The court said, in an opinion sustaining the application of the act to Filburn's activity, one of the primary purposes of the act in question was to increase the market price of wheat, and to that end to limit the volume thereof that could affect the market. It can hardly be denied that a factor of such volume and variability as home-consumed wheat would have a substantial influence on price and market conditions. This may arise because being in marketable condition, such wheat overhangs the market and, if induced by rising prices, tends to flow into the market and check price increases. But if we assume that it is never marketed, it supplies a need of the man who grew it, which would otherwise be reflected by purchases in the open market. Homegrown wheat, in this sense, competes with wheat in commerce. Section 922G is a criminal statute that, by its terms, has nothing to do with commerce or any sort of economic enterprise. However broadly one might define those terms, Section 922G is not an essential part of a larger regulation of economic activity in which the regulatory scheme could be undercut unless the intrastate activity were regulated. It cannot therefore be sustained under our cases upholding regulations of activities that arise out of or are connected with a commercial transaction, which viewed in the aggregate substantially affects interstate commerce. Second, Section 922G contains no jurisdictional element which would ensure, through case-by-case inquiry, that the firearm possession in question affects interstate commerce. For example, in United States v. Bass, the court interpreted former 18 U.S.C. Section 1202A, which made it a crime for a felon to receive, possess, or transport in commerce or affecting commerce any firearm. The court interpreted the possession component of Section 1202A to require an additional nexus to interstate commerce, both because the statute was ambiguous and because, unless Congress conveys its purpose clearly, it will not be deemed to have significantly changed the federal-state balance. The Bass court set aside the conviction because, although the government had demonstrated that Bass had possessed a firearm, it had failed to show the requisite nexus with interstate commerce. The court thus interpreted the statute to reserve the constitutional question whether Congress could regulate, without more, the mere possession of firearms. Unlike the statute in Bass, Section 922G has no express jurisdictional element which might limit its reach to a discrete set of firearm possessions that additionally have an explicit connection with or effect on interstate commerce. Although, as part of our independent evaluation of constitutionality under the Commerce Clause, we of course consider legislative findings, and indeed even Congressional committee findings regarding effect on interstate commerce, the government concedes that neither the statute nor its legislative history contains express congressional findings regarding the effects upon interstate commerce of gun possession in a school zone. We agree with the government that Congress normally is not required to make formal findings as to the substantial burdens that an activity has on interstate commerce. But to the extent that congressional findings would enable us to evaluate the legislative judgment that the activity in question substantially affected interstate commerce, even though no such substantial effect was visible to the naked eye, they are lacking here. The government argues that Congress has accumulated institutional expertise regarding the regulation of firearms through previous enactments. We agree, however, with the Fifth Circuit that importation of previous findings to justify Section 922G is especially inappropriate here, because the prior federal enactments of congressional findings do not speak to the subject matter of Section 922G or its relationship to interstate commerce. Indeed, Section 922G plows thoroughly new ground and represents a sharp break with the long-standing pattern of federal firearms legislation. The government's essential contention, in fine, is that we may determine here that Section 922G is valid because possession of a firearm in a local school zone does indeed substantially affect interstate commerce. The government argues that possession of a firearm in a school zone may result in violent crime, and that violent crime can be expected to affect the functioning of the national economy in two ways. First, the costs of violent crime are substantial, and through the mechanism of insurance, those costs are spread throughout the population. Second, violent crime reduces the willingness of individuals to travel to areas within the country that are perceived to be unsafe. The government also argues that the presence of guns in schools poses a substantial threat to the educational process by threatening the learning environment. A handicapped educational process, in turn, will result in a less productive citizenry. That, in turn, would have an adverse effect on the nation's economic well-being. As a result, the government argues that Congress could rationally have concluded that Section 922G substantially affects interstate commerce. We pause to consider the implications of the government's arguments. The government admits, under its cost of crime reasoning, that Congress could regulate not only all violent crime, but all activities that might lead to violent crime, regardless of how tenuously they relate to interstate commerce. Similarly, under the government's national productivity reasoning, Congress could regulate any activity that it found was related to the economic productivity of individual citizens. Family law, including marriage, divorce, and child custody, for example. Under the theories that the government presents in support of Section 922G, it is difficult to perceive any limitation on federal power, even in areas such as criminal law enforcement or education, where states historically have been sovereign. Thus, if we were to accept the government's arguments, we are hard-pressed to posit any activity by an individual that Congress is without power to regulate. Although Justice Breyer argues that acceptance of the government's rationales would not authorize a general federal police power, he is unable to identify any activity that the states may regulate, but Congress may not. Justice Breyer posits that there might be some limitations on Congress's commerce power, such as family law or certain aspects of education. These suggested limitations, when viewed in light of the dissent's expansive analysis, are devoid of substance. Justice Breyer focuses, for the most part, on the threat that firearm possession in and near schools poses to the educational process and the potential economic consequences flowing from that threat. Specifically, the dissent reasons that 1. Gun-related violence is a serious problem, 2. That problem in turn has an adverse effect on classroom learning, and 3. That adverse effect on classroom learning in turn represents a substantial threat to trade and commerce. This analysis would be equally applicable, if not more so, to subjects such as family law and direct regulation of education. For instance, if Congress can, pursuant to its Commerce Clause power, regulate activities that adversely affect the learning environment, then, a fortiori, it also can regulate the educational process directly. Congress could determine that a school's curriculum has a significant effect on the extent of classroom learning. As a result, Congress could mandate a federal curriculum for local elementary and secondary schools because what is taught in local schools has a significant effect on classroom learning, and that in turn has a substantial effect on interstate commerce. Justice Breyer rejects our reading of precedent and argues that Congress could rationally conclude that schools fall on the commercial side of the line. Again, Justice Breyer's rationale lacks any real limits because, depending on the level of generality, any activity can be looked upon as commercial. Under the dissent's rationale, Congress could just as easily look at child rearing as falling on the commercial side of the line because it provides a valuable service, namely to equip children with the skills they need to survive in life, and more specifically in the workplace. We do not doubt that Congress has authority under the Commerce Clause to regulate numerous commercial activities that substantially affect interstate commerce and also affect the educational process. That authority, though broad, does not include the authority to regulate each and every aspect of local schools. Admittedly, a determination whether an intrastate activity is commercial or non-commercial may in some cases result in legal uncertainty. But so long as Congress's authority is limited to those powers enumerated in the Constitution, and so long as those enumerated powers are interpreted as having judicially enforceable outer limits, congressional legislation under the Commerce Clause always will engender legal uncertainty. As Chief Justice Marshall stated in McCulloch v. Maryland, the federal government is acknowledged by all to be one of enumerated powers. The principle that it can exercise only the powers granted to it is now universally admitted. But the question respecting the extent of the powers actually granted is perpetually arising, and will probably continue to arise as long as our system shall exist. The Constitution mandates this uncertainty by withholding from Congress a plenary police power that would authorize enactment of every type of legislation. Congress has operated within this framework of legal uncertainty ever since this court determined that it was the judiciary's duty to say what the law is. Any possible benefit from eliminating this legal uncertainty would be at the expense of the Constitution's system of enumerated powers. In Jones and Laughlin Steele, we held that the question of congressional power under the Commerce Clause is necessarily one of degree. To the same effect is the concurring opinion of Justice Cardozo in Schechter Poultry. There is a view of causation that would obliterate the distinction between what is national and what is local in the activities of commerce. Motion at the outer rim is communicated perceptibly, though minutely, to recording instruments at the center. A society such as ours is an elastic medium which transmits all tremors throughout its territory. The only question is of their size. These are not precise formulations, and in the nature of things they cannot be, but we think they point the way to a correct decision of this case. The possession of a gun in a local school zone is in no sense an economic activity that might, through repetition elsewhere, substantially affect any sort of interstate commerce. Respondent was a local student at a local school. There is no indication that he had recently moved in interstate commerce, and there is no requirement that his possession of the firearm have any concrete tie to interstate commerce. To uphold the government's contentions here, we would have to pile inference upon inference in a manner that would bid fair to convert congressional authority under the Commerce Clause to a general police power of the sort retained by the states. Admittedly, some of our prior cases have taken long steps down that road, giving great deference to congressional action. The broad language in these opinions has suggested the possibility of additional expansion, but we declined here to proceed any further. To do so would require us to conclude that the Constitution's enumeration of powers does not presuppose something not enumerated, and that there never will be a distinction between what is truly national and what is truly local. This we are unwilling to do. For the foregoing reasons, the judgment of the Court of Appeals is affirmed. Justice Kennedy, with whom Justice O'Connor joins, concurring. The history of the judicial struggle to interpret the Commerce Clause during the transition from the economic system the founders knew to the single national market, still emergent in our own era, counsels great restraint before the court determines that the clause is insufficient to support an exercise of the national power. That history gives me some pause about today's decision, but I join the court's opinion with these observations on what I conceive to be its necessary though limited holding. Chief Justice Marshall announced that the national authority reaches that commerce which concerns more states than one, and that the commerce power is complete in itself, may be exercised to its utmost extent, and acknowledges no limitations other than are prescribed in the Constitution. Gibbons v. Ogden. His statements can be understood now as an early and authoritative recognition that the Commerce Clause grants Congress extensive power and ample discretion to determine its appropriate exercise. The progression of our Commerce Clause cases from Gibbons to the present was not marked, however, by a coherent or consistent course of interpretation, for neither the course of technological advance nor the foundational principles for the jurisprudence itself were self-evident to the courts that sought to resolve contemporary disputes by enduring principles. Furthermore, for almost a century after the adoption of the Constitution, the Court's Commerce Clause decision did not concern the authority of Congress to legislate. Rather, the Court faced the related, but quite distinct question of the authority of the states to regulate matters that would be within the commerce power had Congress chosen to act. The simple fact was that in the early years of the Republic, Congress seldom perceived the necessity to exercise its power in circumstances where its authority would be called into question. The Court's initial task, therefore, was to elaborate the theories that would permit the states to act where Congress had not done so. Not the least part of the problem was the unresolved question whether the congressional power was exclusive, a question reserved by Chief Justice Marshall in Gibbons v. Ogden. At the midpoint of the 19th century, the Court embraced the principle that the states and the national government both have authority to regulate certain matters absent the congressional determination to displace local law or the necessity for the Court to invalidate local law because of the dormant national power. One approach the Court used to inquire into the lawfulness of state authority was to draw content-based or subject matter distinctions, thus defining by semantic or formalistic categories those activities that were commerce and those that were not. For instance, in deciding that a state could prohibit the in-state manufacture of liquor intended for out-of-state shipment, it distinguished between manufacture and commerce. No distinction is more popular to the common mind, or more clearly expressed in economic and political literature, than that between manufacture and commerce. Manufacture is transformation, the fashioning of raw materials into a change of form for use. The functions of commerce are different. Though that approach likely would not have survived, even if confined to this question of a state's authority to enact legislation, it was not at all propitious when applied to the quite different question of what subjects were within the reach of the national power when Congress chose to exercise it. This became evident when the Court began to confront federal economic regulation enacted in response to the rapid industrial development in the late 19th century. Thus, it relied upon the manufacture-commerce dichotomy in United States versus E.C. Knight Corporation, where a manufacturer's combination controlling some 98% of the nation's domestic sugar refining capacity was held to be outside the reach of the Sherman Act. Conspiracies to control manufacture, agriculture, mining, production, wages, or prices, the Court explained, had too indirect an effect on interstate commerce. And in Adair versus United States, the Court rejected the view that the commerce power might extend to activities that, although local in the sense of having originated within a single state, nevertheless had a practical effect on interstate commercial activity. The Court concluded that there was not a legal or logical connection between an employee's membership in a labor organization and the carrying on of interstate commerce, and struck down a federal statute forbidding the discharge of an employee because of his membership in a labor organization. Even before the court committed itself to sustaining federal legislation on broad principles of economic practicality, it found it necessary to depart from these decisions. The court disavowed E.C. Knight's reliance on the manufacturing commerce distinction in Standard Oil Company of New Jersey versus United States, declaring that approach unsound. The court likewise rejected the rationale of Adair when it decided in Texas and New Orleans Railroad Company versus Railway Clerks that Congress had the power to regulate matters pertaining to the organization of railroad workers. In another line of cases, the court addressed Congress's efforts to impede local activities it considered undesirable by prohibiting the interstate movement of some essential element. In the lottery case, the court rejected the argument that Congress lacked power to prohibit the interstate movement of lottery tickets because it had power only to regulate, not to prohibit. In Hammer v. Degenhardt, however, the court insisted that the power to regulate commerce is directly the contrary of the assumed right to forbid commerce from moving, and struck down a prohibition on the interstate transportation of goods manufactured in violation of child labor laws. Even while it was experiencing difficulties in finding satisfactory principles in these cases, the court was pursuing a more sustainable and practical approach in other lines of decisions, particularly those involving the regulation of railroad rates. In the Minnesota rate cases, the court upheld a state rate order by observing that Congress might be empowered to regulate in this area if, by reason of the interblending of the interstate and intrastate operations of interstate carriers, the regulation of interstate rates could not be maintained without restrictions on intrastate rates, which substantially affect the former. And in the Shreveport rate cases, the court upheld an Interstate Commerce Commission order fixing railroad rates with the explanation that congressional authority, extending to these interstate carriers as instruments of interstate commerce, necessarily embraces the right to control their operations in all matters having such a close and substantial relation to interstate traffic that the control is essential or appropriate to the security of that traffic, to the efficiency of the interstate service, and to the maintenance of conditions under which interstate commerce may be conducted upon fair terms and without molestation or hindrance. Even the most confined interpretation of commerce would embrace transportation between the states, so the rate cases posed much less difficulty for the court than cases involving manufacture or production. Nevertheless, the court's recognition of the importance of a practical conception of the commerce power was not altogether confined to the rate cases. In Swift & Co. v. United States, the court upheld the application of federal antitrust law to a combination of meat dealers that occurred in one state, but that restrained trade in cattle sent for sale from a place in one state with the expectation that they will end their transit in another. The court explained that commerce among the states is not a technical legal conception, but a practical one, drawn from the course of business. Chief Justice Taft followed the same approach in upholding federal regulation of stockyards in Stafford v. Wallace. Speaking for the court, he rejected a nice and technical inquiry when the local transactions at issue could not be separated from the movement to which they contribute. Reluctance of the court to adopt that approach in all of its cases caused inconsistencies in doctrine to persist, however. In addressing New Deal legislation, the court resuscitated the abandoned abstract distinction between direct and indirect effects on interstate commerce. The case that seems to mark the court's definitive commitment to the practical conception of the commerce power is NLRB versus Jones and Laughlin Steel Corporation, where the court sustained labor laws that apply to manufacturing facilities, making no real attempt to distinguish Carter and Schechter. The deference given to Congress has since been confirmed. United States v. Darby overruled Hammer v. Degenhardt, and in Wickard v. Filburn, the court disapproved E.C. Knight and the entire line of direct, indirect, and manufacturer production cases, explaining that broader interpretations of the Commerce Clause were destined to supersede the earlier ones, and whatever terminology is used, the criterion is necessarily one of degree and must be so defined. This does not satisfy those who seek mathematical or rigid formulas, but such formulas are not provided by the great concepts of the Constitution. Later examples of the exercise of federal power where commercial transactions were the subject of regulation include Heart of Atlanta Motel, Inc. versus United States, Katzenbach v. McClung, and Perez v. United States. These, and like authorities, are within the fair ambit of the court's practical conception of commercial regulation and are not called in question by our decision today. The history of our Commerce Clause decisions contains at least 2 lessons of relevance to this case. The first, as stated at the outset, is the imprecision of content-based boundaries used without more to define the limits of the Commerce Clause. The second, related to the first, but of even greater consequence, is that the court as an institution and the legal system as a whole have an immense stake in the stability of our Commerce Clause jurisprudence as it has evolved to this point. Stare decisis operates with great force in counseling us not to call in question the essential principles now in place respecting the congressional power to regulate transactions of a commercial nature. That fundamental restraint on our power forecloses us from reverting to an understanding of commerce that would serve only an 18th century economy, dependent then upon production and trading practices that had changed but little over the preceding centuries. It also mandates against returning to the time when congressional authority to regulate undoubted commercial activities was limited by a judicial determination that those matters had an insufficient connection to an interstate system. Congress can regulate in the commercial sphere on the assumption that we have a single market and a unified purpose to build a stable national economy. In referring to the whole subject of the federal and state balance, we said this just 3 terms ago. This framework has been sufficiently flexible over the past 2 centuries to allow for enormous changes in the nature of government. The federal government undertakes activities today that would have been unimaginable to the framers in 2 senses. First, because the framers would not have conceived that any government would conduct such activities. And second, because the framers would not have believed that the federal government, rather than the states, would assume such responsibilities. Yet the powers conferred upon the federal government by the Constitution were phrased in language broad enough to allow for the expansion of the federal government's role. New York versus the United States. It does not follow, however, that in every instance the court lacks the authority and responsibility to review congressional attempts to alter the federal balance. This case requires us to consider our place in the design of the government and to appreciate the significance of federalism in the whole structure of the Constitution. Of the various structural elements in the Constitution, separation of power, checks and balances, judicial review, and federalism, only concerning the last does there seem to be much uncertainty respecting the existence and the content of standards that allowed the judiciary to play a significant role in maintaining the design contemplated by the framers. Although the resolution of specific cases has proved difficult, we have derived from the Constitution workable standards to assist in preserving separation of powers and checks and balances. These standards are by now well accepted. Judicial review is also established beyond question in Marbury versus Madison, and though we may differ when applying its principles, its legitimacy is undoubted. Our role in preserving the federal balance seems more tenuous. There is irony in this because of the 4 structural elements of the Constitution just mentioned. Federalism was the unique contribution of the framers to political science and political theory. Though on the surface the idea may seem counterintuitive, it was the insight of the framers that freedom was enhanced by the creation of 2 governments, not 1. In the Compound Republic of America, the power surrendered by the people is first divided between 2 distinct governments, and then the portion allotted to each subdivided among distinct and separate departments. Hence, a double security arises to the rights of the people. The different governments will control each other at the same time that each will be controlled by itself. The theory that 2 governments accord more liberty than 1 requires for its realization 2 distinct and discernible lines of political accountability. One between the citizens and the federal government, the second between the citizens and the states. If, as Madison expected, the federal and state governments are to control each other and hold each other in check by competing for the affections of the people, see Federalist number 46, those citizens must have some means of knowing which of the two governments to hold accountable for the failure to perform a given function. Were the federal government to take over the regulation of entire areas of traditional state concern, areas having nothing to do with the regulation of commercial activities, the boundaries between the spheres of federal and state authority would blur and political responsibility would become illusory. The resultant inability to hold either branch of the government answerable to the citizens is more dangerous even than devolving too much authority to the remote central power. To be sure, one conclusion that could be drawn from the Federalist Papers is that the balance between national and state power is entrusted in its entirety to the political process. Madison's observation that the people ought not surely to be precluded from giving most of their confidence where they may discover it to be most due, the Federalist number 46 can be interpreted to say that the essence of responsibility for a shift in power from the state to the federal government rests upon a political judgment, though he added assurance that the state governments could have little to apprehend, because it is only within a certain sphere that the federal power can, in the nature of things, be advantageously administered. Whatever the judicial rule, it is axiomatic that Congress does have substantial discretion and control over the federal balance. For these reasons, it would be mistaken and mischievous for the political branches to forget that the sworn obligation to preserve and protect the Constitution in maintaining the federal balance is their own in the first and primary instance. In the Webster-Hayne debates and the debates over the Civil Rights Acts, some Congresses have accepted responsibility to confront the great questions of the proper federal balance in terms of lasting consequences for the constitutional design. The political branches of the government must fulfill this grave constitutional obligation if democratic liberty and the federalism that secures it are to endure. At the same time, the absence of structural mechanism to require those officials who undertake this principal task and the momentary political convenience often attendant upon their failure to do so argue against a complete renunciation of the judicial role. Although it is the obligation of all officers of the government to respect the constitutional design, the federal balance is too essential a part of our constitutional structure and plays too vital a role in securing freedom for us to admit inability to intervene when one or the other level of government has tipped the scales too far. In the past, this court has participated in maintaining the federal balance through judicial exposition of doctrines such as abstention, the rules for determining the primacy of state law, the doctrine of adequate and independent state grounds, the whole jurisprudence of preemption, and many of the rules governing our habeas jurisprudence. Our ability to preserve this principle under the Commerce Clause has presented a much greater challenge. This clause has, throughout the court's history, been the chief source of its adjudications regarding federalism, and no other body of opinions affords a fairer or more revealing test of judicial qualities. But as the branch whose distinctive duty it is to declare what the law is, we are often called upon to resolve questions of constitutional law not susceptible to the mechanical application of bright and clear lines. The substantial element of political judgment in Commerce Clause matters leaves our institutional capacity to intervene more in doubt than when we decide cases, for instance, under the Bill of Rights, even though clear and bright lines are often absent in the latter class of disputes. But our cases do not teach that we have no role at all in determining the meaning of the Commerce Clause. Our position in enforcing the dormant Commerce Clause is instructive. The court's doctrinal approach in that area has likewise taken some turns. Yet in contrast to the prevailing skepticism that surrounds our ability to give meaning to the explicit text of the Commerce Clause, there is widespread acceptance of our authority to enforce the Dormant Commerce Clause, which we have but inferred from the constitutional structure as a limitation on the power of the states. One element of our Dormant Commerce Clause jurisprudence has been the principle that the states may not impose regulations that place an undue burden on interstate commerce, even where those regulations do not discriminate between in-state and out-of-state businesses. Distinguishing between regulations that do place an undue burden on interstate commerce and regulations that do not depends upon delicate judgments. True, if we invalidate a state law, Congress can, in effect, overturn our judgment, whereas in a case announcing that Congress has transgressed its authority, the decision is more consequential, for it stands unless Congress can revise its law to demonstrate its commercial character. This difference no doubt informs the circumspection with which we invalidate an act of Congress, but it does not mitigate our duty to recognize meaningful limits on the commerce power of Congress. The statute before us upsets the federal balance to a degree that renders it an unconstitutional assertion of commerce power, and our intervention is required. As the Chief Justice explains, unlike the earlier cases to come before the court, here neither the actors nor their conduct have a commercial character, and neither the purpose nor the design of the statute have an evident commercial nexus. The statute makes the simple possession of a gun within 1,000 feet of the grounds of the school a criminal offense. In a sense, any conduct in this interdependent world of ours has an ultimate commercial origin or consequence. But we have not yet said the commerce power may reach so far. If Congress attempts that extension, then, at the least, we must inquire whether the exercise of national power seeks to intrude upon an area of traditional state concern. An interference of these dimensions occurs here, for it is well established that education is a traditional concern of the states. The proximity to schools, including, of course, schools owned and operated by the states or their subdivisions, is the very premise for making the conduct criminal. In these circumstances, we have a particular duty to ensure that the federal-state balance is not destroyed. While it is doubtful that any state, or indeed any reasonable person, would argue that it is a wise policy to allow students to carry guns on school premises, considerable disagreement exists about how best to accomplish that goal. In this circumstance, the theory and utility of our federalism are revealed, for the states may perform their role as laboratories for experimentation to devise various solutions where the best solution is far from clear. If a state or municipality determines that harsh criminal sanctions are necessary and wise to deter students from carrying guns on school premises, the reserve powers of the states are sufficient to enact those measures. Indeed, over 40 states already have criminal laws outlawing the possession of firearms on or near school grounds. Other, more practicable means to rid the schools of guns may be thought by the citizens of some states to be preferable for the safety and welfare of the schools those states are charged with maintaining. These might include inducements to inform on violators where the information leads to arrest or confiscation of the guns. The statute now before us forecloses the states from experimenting and exercising their own judgment in an area to which states lay claim by right of history and expertise, and it does so by regulating an activity beyond the realm of commerce in the ordinary and usual sense of that term. The tendency of this statute to displace state regulation in areas of traditional state concern is evident from its territorial operation. There are over 100,000 elementary and secondary schools in the United States. Each of these now has an invisible federal zone extending 1,000 feet beyond the often irregular boundaries of the school property. In some communities, no doubt, it would be difficult to navigate without infringing on those zones. Yet throughout these areas, school officials would find their own programs for the prohibition of guns in danger of displacement by the federal authority, unless the state chooses to enact a parallel rule. This is not a case where the etiquette of federalism has been violated by a formal command from the national government directing the state to enact a certain policy, or to organize its governmental functions in a certain way. While the intrusion on state sovereignty may not be as severe in this instance as in some of our recent 10th Amendment cases, the intrusion is nonetheless significant. Absent a stronger connection or identification with commercial concerns that are central to the Commerce Clause, that interference contradicts the federal balance the framers designed and that this court is obliged to enforce. For these reasons, I join in the opinion and judgment of the court. Justice Thomas concurring. The court today properly concludes that the Commerce Clause does not grant Congress the authority to prohibit gun possession within 1,000 feet of a school, as it attempted to do in the Gun-Free School Zones Act of 1990. Although I join the majority, I write separately to observe that our case law has drifted far from the original understanding of the Commerce Clause. In a future case, we ought to temper our Commerce Clause jurisprudence in a manner that both makes sense of our more recent case law and is more faithful to the original understanding of that clause. We have said that Congress may regulate not only commerce among the several states, but also anything that has a substantial effect on such commerce. This test, if taken to its logical extreme, would give Congress a police power over all aspects of American life. Unfortunately, we have never come to grips with this implication of our substantial effects formula. Although we have supposedly applied the substantial effects test for the past 60 years, we always have rejected readings of the Commerce Clause and the scope of federal power that would permit Congress to exercise a police power. Our cases are quite clear that there are real limits to federal power. Indeed, on this crucial point, the majority and Justice Breyer agree in principle. The federal government has nothing approaching a police power. While the principal dissent concedes that there are limits to federal power, the sweeping nature of our current test enables the dissent to argue that Congress can regulate gun possession. But it seems to me that the power to regulate commerce can by no means encompass authority over mere gun possession, any more than it empowers the federal government to regulate marriage, littering, or cruelty to animals throughout the 50 states. Our Constitution quite properly leaves such matters to the individual states, notwithstanding these activities' effects on interstate commerce. Any interpretation of the Commerce Clause that even suggests that Congress could regulate such matters is in need of re-examination. In an appropriate case, I believe that we must further reconsider our substantial effects test with an eye toward constructing a standard that reflects the text and history of the Commerce Clause without totally rejecting our more recent Commerce Clause jurisprudence. Today, however, I merely support the Court's conclusion with a discussion of the text, structure, and history of the Commerce Clause and an analysis of our early case law. My goal is simply to show how far we have departed from the original understanding and to demonstrate that the result we reach today is by no means radical. I also want to point out the necessity of refashioning a coherent test that does not tend to obliterate the distinction between what is national and what is local and create a completely centralized government. At the time the original Constitution was ratified, commerce consisted of selling, buying, and bartering, as well as transporting for these purposes. In fact, when Federalists and Anti-Federalists discussed the Commerce Clause during the ratification period, they often used trade in its selling and bartering sense and commerce interchangeably. As one would expect, the term commerce was used in contradistinction to productive activities such as manufacturing and agriculture. Alexander Hamilton, for example, repeatedly treated commerce, agriculture, and manufacturing as three separate endeavors. The same distinctions were made in the state ratification conventions. Moreover, interjecting a modern sense of commerce into the Constitution generates significant textual and structural problems. For example, one cannot replace commerce with a different type of enterprise, such as manufacturing. When a manufacturer produces a car, assembly cannot take place with a foreign nation or with the Indian tribes. Parts may come from different states or other nations and hence may have been in the flow of commerce at one time, but manufacturing takes place at a discrete site. Agriculture and manufacturing involve the production of goods. Commerce encompasses traffic in such articles. The Port Preference Clause also suggests that the term commerce denoted sale and/or transport, rather than business generally. According to that clause, no preference shall be given by any regulation of commerce or revenue to the ports of one state over those of another. Although it is possible to conceive of regulations of manufacturing or farming that prefer one port over another, the more natural reading is that the clause prohibits Congress from using its commerce power to channel commerce through certain favored ports. The Constitution not only uses the word commerce in a narrower sense than our case law might suggest, it also does not support the proposition that Congress has authority over all activities that substantially affect interstate commerce. The Commerce Clause does not state that Congress may regulate matters that substantially affect commerce with foreign nations and among the several states and with the Indian tribes. In contrast, the Constitution itself temporarily prohibited amendments that would affect Congress's lack of authority to prohibit or restrict the slave trade or to enact unproportioned direct taxation. Clearly, the framers could have drafted a constitution that contained a substantially affects interstate commerce clause had that been their objective. In addition to its powers under the Commerce Clause, Congress has the authority to enact such laws as are necessary and proper to carry into execution its power to regulate commerce among the several states. But on this court's understanding of congressional power under these two clauses, many of Congress's other enumerated powers under Article 1, Section 8 are wholly superfluous. After all, if Congress may regulate all matters that substantially affect commerce, there is no need for the Constitution to specify that Congress may enact bankruptcy laws, or coin money and fix the standard of weights and measures, or punish counterfeiters of United States coin and securities. Likewise, Congress would not need the separate authority to establish post offices and post roads, or to grant patents and copyrights, or to punish piracies and felonies committed on the high seas. It might not even need the power to raise and support an army and navy, for fewer people would engage in commercial shipping if they thought that a foreign power could expropriate their property with ease. Indeed, if Congress could regulate matters that substantially affect interstate commerce, there would have been no need to specify that Congress can regulate international trade and commerce with the Indians. As the framers surely understood, these other branches of trade substantially affect interstate commerce. Put simply, much, if not all, of Article 1, Section 8, including portions of the Common Clause itself, would be surplusage if Congress had been given authority over matters that substantially affect interstate commerce. An interpretation of Clause 3 that makes the rest of Section 8 superfluous simply cannot be correct. Yet this Court's Commerce Clause jurisprudence has endorsed just such an interpretation. The power we have accorded Congress has swallowed Article 1, Section 8. Indeed, if a substantial effects test can be appended to the Commerce Clause, why not to every other power of the federal government? There is no reason for singling out the Commerce Clause for special treatment. Accordingly, Congress could regulate all matters that substantially affect the Army and Navy, bankruptcies, tax collection, expenditures, and so on. In that case, the clauses of Section 8 all mutually overlap, something we can assume the Founding Fathers never intended. Our construction of the scope of congressional authority has the additional problem of coming close to turning the 10th Amendment on its head. Our case law could be read to reserve to the United States all powers not expressly prohibited by the Constitution. Taken together, these fundamental textual problems should, at the very least, convince us that the substantial effects test should be re-examined. The exchanges during the ratification campaign reveal the relatively limited reach of the Commerce Clause and of federal power generally. The Founding Fathers confirmed that most areas of life, even many matters that would have substantial effects on commerce would remain outside the reach of the federal government. Such affairs would continue to be under the exclusive control of the states. Early Americans understood that commerce, manufacturing, and agriculture, while distinct activities, were intimately related and dependent on each other, that each substantially affected the others. After all, items produced by farmers and manufacturers were the primary articles of commerce at the time. If commerce was more robust as a result of federal superintendence, farmers and manufacturers could benefit. Thus, Oliver Ellsworth of Connecticut attempted to convince farmers of the benefits of regulating commerce. Your property and riches depend on a ready demand and generous price for the produce you can annually spare, he wrote, and these conditions exist where trade flourishes and when the merchant can freely export the produce of the country to nations that will pay the highest price. Yet, despite being well aware that agriculture, manufacturing, and other matters substantially affected commerce, the founding generation did not cede authority over all these activities to Congress. Hamilton, for instance, acknowledged that the federal government could not regulate agriculture and like concerns. The administration of private justice between the citizens of the same state, the supervision of agriculture and of other concerns of a similar nature, all those things, in short, which are proper to be provided for by local legislation, can never be desirable cares of a general jurisdiction. In the unlikely event that the federal government would attempt to exercise authority over such matters, its effort would be as troublesome as it would be nugatory. The comments of Hamilton and others about federal power reflected the well-known truth that the new government would have only the limited and enumerated powers found in the Constitution. Even before the passage of the 10th Amendment, it was apparent that Congress would possess only those powers herein granted by the rest of the Constitution, Article 1, Section 1. Where the Constitution was meant to grant federal authority over an activity substantially affecting interstate commerce, the Constitution contains an enumerated power over that particular activity. Indeed, the framers knew that many of the other enumerated powers in Section 8 dealt with matters that substantially affected interstate commerce. Madison, for instance, spoke of the bankruptcy power as being intimately connected with the regulation of commerce. Likewise, Hamilton urged that if we mean to be a commercial people or even to be secure on our Atlantic side, we must endeavor as soon as possible to have a navy. In short, the Founding Fathers were well aware of what the principal dissent calls economic realities. Even though the boundary between commerce and other matters may ignore economic reality and thus seem arbitrary or artificial to some, we must nevertheless respect a constitutional line that does not grant Congress power over all that substantially affects interstate commerce. If the principal dissent's understanding of our early case law were correct, there might be some reason to doubt this view of the original understanding of the Constitution. According to that dissent, Chief Justice Marshall's opinion in Gibbons v. Ogden established that Congress may control all local activities that significantly affect interstate commerce and, with the exception of one wrong turn subsequently corrected, this has been the traditional method of interpreting the Commerce Clause. In my view, the dissent is wrong about the holding and reasoning of Gibbons. Because this error leads the dissent to characterize the first 150 years of this court's case law as a wrong turn, I feel compelled to put the last 50 years in proper perspective. In Gibbons, the court examined whether a federal law that licensed ships to engage in the coasting trade preempted a New York law granting a 30-year monopoly to Robert Livingston and Robert Fulton to navigate the state's waterways by steamship. In concluding that it did, the court noted that Congress could regulate navigation because all America had uniformly understood the word commerce to comprehend navigation. It was so understood and must have been so understood when the Constitution was framed. The court also observed that federal power over commerce among the several states meant that Congress could regulate commerce conducted partly within a state. Because a portion of interstate commerce and foreign commerce would almost always take place within one or more states, federal power over interstate and foreign commerce necessarily would extend into the states. At the same time, the court took great pains to make clear that Congress could not regulate commerce which is completely internal, which is carried on between man and man in a state, or between different parts of the same state, and which does not extend to or affect other states. Moreover, while suggesting that the Constitution might not permit states to regulate interstate or foreign commerce, the court observed that inspection laws, quarantine laws, health laws of every description, as well as laws for regulating the internal commerce of a state, were but a small part of that immense mass of legislation, not surrendered to a general government. From an early moment, the court rejected the notion that Congress can regulate everything that affects interstate commerce, that the internal commerce of the states and the numerous state inspection, quarantine, and health laws had substantial effects on interstate commerce cannot be doubted. Nevertheless, they were not surrendered to the general government. Of course, the principal dissent is not the first to misconstrue Gibbons. For instance, the court has stated that Gibbons described the federal commerce power with a breadth never yet exceeded. I believe that this misreading stems from two statements in Gibbons. First, the court made the uncontroversial claim that federal power does not encompass commerce that does not extend to or affect other states. From this statement, the principal dissent infers that whenever an activity affects interstate commerce, it necessarily follows that Congress can regulate such activities. Of course, Chief Justice Marshall said no such thing, and the inference the dissent makes cannot be drawn. There is a much better interpretation of the effects language. Because the court had earlier noted that the commerce power did not extend to wholly intrastate commerce, the court was acknowledging that although the line between intrastate and interstate or foreign commerce would be difficult to draw, federal authority could not be construed to cover purely intrastate commerce. Commerce that did not affect another state could never be said to be commerce among the several states. But even if one were to adopt the dissent's reading, the effects language, at most, permits Congress to regulate only intrastate commerce that substantially affects interstate and foreign commerce. There is no reason to believe that Chief Justice Marshall was asserting that Congress could regulate all activities that affect interstate commerce. The second source of confusion stems from the court's praise for the Constitution's division of power between the states and the federal government. The genius and character of the whole government seem to be that its action is to be applied to all the external concerns of the nation, and to those internal concerns which affect the states generally, but not to those which are completely within a particular state, which do not affect other states, and with which it is not necessary to interfere for the purpose of executing some of the general powers of the government. In this passage, the court merely was making the well-understood point that the Constitution commits matters of national concern to Congress and leaves local matters to the states. The court was not saying that whatever Congress believes is a national matter becomes an object of federal control. The matters of national concern are enumerated in the Constitution: war, taxes, patents and copyrights, uniform rules of naturalization and bankruptcy, types of commerce, and so on. Gibbons' emphatic statements that Congress could not regulate many matters that affect commerce confirm that the court did not read the Commerce Clause as granting Congress control over matters that affect the states generally. Gibbons simply cannot be construed as the principal dissent would have it. I am aware of no cases prior to the New Deal that characterize the power flowing from the Commerce Clause as sweepingly as does our substantial effects test. My review of the case law indicates that the substantial effects test is but an innovation of the 20th century. Even before Gibbons, Chief Justice Marshall, writing for the court in Cohens v. Virginia, noted that Congress had no general right to punish murder committed with any of the states, and that it was clear that Congress cannot punish felonies generally. The court's only qualification was that Congress could enact such laws for places where it enjoyed plenary powers, for instance, over the District of Columbia. Thus, whatever effect ordinary murders or robbery or gun possession might have on interstate commerce, or on any other subject of federal concern, was irrelevant to the question of congressional power. United States v. DeWitt marked the first time the court struck down a federal law as exceeding the power conveyed by the Commerce Clause. In a 2-page opinion, the court invalidated a nationwide law prohibiting all sales of naphtha and illuminating oils. In so doing, the court remarked that the Commerce Clause has always been understood as limited by its terms and as a virtual denial of any power to interfere with the internal trade and business of the separate states. The law in question was plainly a regulation of police, which could have constitutional application only where Congress had exclusive authority, such as the territories. In United States v. E.C. Knight Company, the court held that mere attempts to monopolize the manufacture of sugar could not be regulated pursuant to the Commerce Clause. Raising echoes of the discussions of the framers regarding the intimate relationship between commerce and manufacturing, the court declared that commerce succeeds to manufacture and is not a part of it. The court also approvingly quoted from Kidd v. Pearson, "No distinction is more popular to the common mind or more clearly expressed in economic and political literature than that between manufacture and commerce. If it be held that the term commerce includes the regulation of all such manufactures as are intended to be the subject of commercial transactions in the future, it is impossible to deny that it would also include all productive industries that contemplate the same thing. The result would be that Congress would be invested with the power to regulate not only manufactures, but also agriculture, horticulture, stock raising, domestic fisheries, mining, in short, every branch of human industry. If federal power extended to these types of production, comparatively little of business operations and affairs would be left for state control. Whether or not manufacturing, agriculture, or other matters substantially affected interstate commerce was irrelevant." As recently as 1936, the court continued to insist that the Commerce Clause did not reach the wholly internal business of the states. The federal government simply could not reach such subjects regardless of their effects on interstate commerce. These cases all established a simple point. From the time of the ratification of the Constitution to the mid-1930s, it was widely understood that the Constitution granted Congress only limited powers, notwithstanding the Commerce Clause. Moreover, there was no question that activities wholly separated from business, such as gun possession, were beyond the reach of the commerce power. If anything, the wrong turn was the court's dramatic departure in the 1930s from a century and a half of precedent. Apart from its recent vintage and its corresponding lack of any grounding in the original understanding of the Constitution, the substantial effects test suffers from the further flaw that it appears to grant Congress a police power over the nation. When asked at oral argument if there were any limits to the Commerce Clause, the government was at a loss for words. Likewise, the principal dissent insists that there are limits, but it cannot muster even one example. Indeed, the dissent implicitly concedes that its reading has no limits when it criticizes the court for threatening legal uncertainty in an area of law that seemed reasonably well settled. The one advantage of the dissent standard is certainty. It is certain that under its analysis, everything may be regulated under the guise of the Commerce Clause. The substantial effects test suffers from this flaw in part because of its aggregation principle. Under so-called class of activities statute, Congress can regulate whole categories of activities that are not themselves either interstate or commerce. In applying the effects test, we ask whether the class of activities as a whole substantially affects interstate commerce, not whether any specific activity within the class has such effects when considered in isolation. The aggregation principle is clever, but has no stopping point. Suppose all would agree that gun possession within 1,000 feet of a school does not substantially affect commerce, but that possession of weapons generally, knives, brass knuckles, nunchucks, etc., does. Under our substantial effects doctrine, even though Congress cannot single out gun possession, it can prohibit weapon possession generally. But one always can draw the circle broadly enough to cover an activity that, when taken in isolation, would not have substantial effects on commerce. Under our jurisprudence, if Congress passed an omnibus substantially affects interstate commerce statute purporting to regulate every aspect of human existence, the act apparently would be constitutional. Even though particular sections may govern only trivial activities, the statute in the aggregate regulates matters that substantially affect commerce. This extended discussion of the original understanding in our first century and a half of case law does not necessarily require a wholesale abandonment of our more recent opinions. It simply reveals that our substantial effects test is far removed from both the Constitution and from our early case law, and that the court's opinion should not be viewed as radical or another wrong turn that must be corrected in the future. The analysis also suggests that we ought to temper our Commerce Clause jurisprudence. Unless the dissenting justices are willing to repudiate our long-held understanding of the limited nature of federal power, I would think that they, too, must be willing to reconsider the substantial effects test in a future case. If we wish to be true to a constitution that does not cede a police power to the federal government, our Commerce Clause's boundaries simply cannot be defined as being commensurate with the national needs, or self-consciously intended to let the federal government defend itself against economic forces that Congress decrees inimical or destructive of the national economy. Such a formulation of federal power is no test at all. It is a blank check. At an appropriate juncture, I think we must modify our Commerce Clause jurisprudence. Today, it is easy enough to say that the clause certainly does not empower Congress to ban gun possession within 1,000 feet of a school. Justice Stevens dissenting. The welfare of our future commerce with foreign nations and among the several states is vitally dependent on the character of the education of our children. I therefore agree entirely with Justice Breyer's explanation of why Congress has ample power to prohibit the possession of firearms in or near schools, just as it may protect the school environment from harms posed by controlled substances such as asbestos or alcohol. I also agree with Justice Souter's exposition of the radical character of the court's holding and its kinship with the discredited pre-Depression version of substantive due process. I believe, however, that the court's extraordinary decision merits this additional comment. Guns are both articles of commerce and articles that can be used to restrain commerce. Their possession is the consequence, either directly or indirectly, of commercial activity. In my judgment, Congress's power to regulate commerce in firearms includes the power to prohibit possession of guns at any location because of their potential harmful use. It necessarily follows that Congress may also prohibit their possession in particular markets. The market for the possession of handguns by school-aged children is distressingly substantial. Whether or not the national interest in eliminating that market would have justified federal legislation in 1789, it surely does today. Justice Souter dissenting. In reviewing congressional legislation under the Commerce Clause, we defer to what is often a merely implicit congressional judgment that its regulation addresses a subject substantially affecting interstate commerce if there is any rational basis for such a finding. If that congressional determination is within the realm of reason, the only remaining question for judicial inquiry is whether the means chosen by Congress are reasonably adapted to the end permitted by the Constitution. The practice of deferring to rationally based legislative judgments is a paradigm of judicial restraint. In judicial review under the Commerce Clause, it reflects our respect for the institutional competence of the Congress on a subject expressly assigned to it by the Constitution, and our appreciation of the legitimacy that comes from Congress's political accountability in dealing with matters open to a wide range of possible choices. It was not ever thus, however, as even a brief overview of Commerce Clause history during the past century reminds us. The modern respect for the competence and primacy of Congress in matters affecting commerce developed only after one of this court's most chastening experiences, when it perforce repudiated an earlier and untenably expansive conception of judicial review and derogation of congressional commerce power. A look at history's sequence will serve to show how today's decision tugs the court off course, leading it to suggest opportunities for further developments that would be at odds with the rule of restraint, to which the court still wisely states adherence. Notwithstanding the court's recognition of a broad commerce power in Gibbons v. Ogden, Congress saw few occasions to exercise that power prior to Reconstruction, and it was really the passage of the Interstate Commerce Act of 1887 that opened a new age of congressional reliance on the Commerce Clause for authority to exercise general police powers at the national level. Although the court upheld a fair amount of the ensuing legislation as being within the commerce power, the period from the turn of the century to 1937 is better noted for a series of cases applying highly formalistic notions of commerce to invalidate federal social and economic legislation. These restrictive views of commerce subject to congressional power complemented the court's activism in limiting the enforceable scope of state economic regulation. It is most familiar history that during this same period, the court routinely invalidated state social and economic legislation under an expansive conception of 14th Amendment substantive due process. The fulcrums of judicial review in these cases were the notions of liberty and property characteristic of laissez-faire economics, whereas the Commerce Clause cases turned on what was ostensibly a structural limit of federal power. But under each conception of judicial review, the court's character for the first third of the century showed itself in exacting judicial scrutiny of the legislature's choice of economic ends and of the legislative means selected to reach them. It was not merely coincidental, then, that sea changes in the court's conceptions of its authority under the Due Process and Commerce Clauses occurred virtually together. In 1937, with West Coast Hotel Co. v. Parrish, and NLRB versus Jones and Laughlin Steel Corp. In West Coast Hotel, the court's rejection of a due process challenge to a state law fixing minimum wages for women and children marked the abandonment of its expansive protection of contractual freedom. 2 weeks later, Jones and Laughlin affirmed congressional commerce power to authorize NLRB injunctions against unfair labor practices. The court's finding that the regulated activity had a direct enough effect on commerce has since been seen as beginning the abandonment, for practical purposes, of the formalistic distinction between direct and indirect effects. In the years following these decisions, deference to legislative policy judgments on commercial regulation became the powerful theme under both the Due Process and Commerce Clauses. And in due course, that deference became articulate in the standard of rationality review. In due process litigation, the court's statement of a rational basis test came quickly. The parallel formation of the Commerce Clause test came later, only because complete elimination of the direct-indirect effects dichotomy and acceptance of the cumulative effects doctrine so far settled the pressing issues of congressional power over commerce as to leave the court for years without any need to phrase a test explicitly deferring to rational legislative judgments. The moment came, however, with the challenge to Congressional Commerce Clause authority to prohibit racial discriminations in places of public accommodation, when the court simply made explicit what the earlier cases had implied, where we find that the legislators, in light of the facts and testimony before them, have a rational basis for finding a chosen regulatory scheme necessary to the protection of commerce. Our investigation is at an end. Thus, under commerce, as under due process, adoption of rational basis review expressed the recognition that the court had no sustainable basis for subjecting economic regulation as such to judicial policy judgments, and for the past half-century the court has no more turned into the direction of formalistic Commerce Clause review, as in deciding whether regulation of commerce was sufficiently direct, than it has inclined toward reasserting the substantive authority of Lochner due process, as in the inflated protection of contractual autonomy. There is today, however, a backward glance at both the old pitfalls as the court treats deference under the rationality rule as subject to gradation according to the commercial or non-commercial nature of the immediate subject of the challenge regulation. The distinction between what is patently commercial and what is not looks much like the old distinction between what directly affects commerce and what touches it only indirectly. And the act of calibrating the level of deference by drawing a line between what is patently commercial and what is less purely so will probably resemble the process of deciding how much interference with contractual freedom was fatal. Thus, it seems fair to ask whether the step taken by the court today does anything but portend a return to the untenable jurisprudence from which the court extricated itself almost 60 years ago. The answer is not reassuring. To be sure, the occasion for today's decision reflects a century's end, not its beginning. But if it seems anomalous that the Congress of the United States has taken to regulating schoolyards, the act in question is still probably no more remarkable than state regulation of bake shops 90 years ago. In any event, There is no reason to hope that the court's qualification of rational basis review will be any more successful than the efforts at substantive economic review made by our predecessors as the century began. Taking the court's opinion on its own terms, Justice Breyer has explained both the hopeless porosity of commercial character as a ground of Commerce Clause distinction in America's highly connected economy and the inconsistency of this categorization with our rational basis precedents from the last 50 years. Further glosses on rationality review, moreover, may be in the offing. Although this case turns on commercial character, the court gestures toward two other considerations that it might sometime entertain in implying rational basis scrutiny, apart from a statutory obligation to supply independent proof of a jurisdictional element. Does the Congressional statute deal with subjects of traditional state regulation? And does the statute contain explicit factual findings supporting the otherwise implicit determination that the regulated activity substantially affects interstate commerce? Once again, any appeal these considerations may have depends on ignoring the painful lesson learned in 1937, for neither of the court's suggestions would square with rational basis scrutiny. The court observes that the Gun-Free School Zones Act operates in two areas traditionally subject to legislation by the states: education and enforcement of criminal law. The suggestion is either that a connection between commerce and these subjects is remote, or that the commerce power is simply weaker when it touches subjects on which the states have historically been the primary legislators. Neither suggestion is tenable. As for remoteness, it may or may not be wise for the national government to deal with education, but Justice Breyer has surely demonstrated that the commercial prospects of an illiterate state or nation are not rosy, and no argument should be needed to show that hijacking interstate shipments of cigarettes can affect commerce substantially, even though the states have traditionally prosecuted robbery. And as for the notion that the commerce power diminishes the closer it gets to customary state concerns, that idea has been flatly rejected and not long ago. The commerce power, have often observed, is plenary. Justice Harlan put it this way in speaking for the court in Maryland v. Wirtz. There is no general doctrine implied in the federal Constitution that the two governments, national and state, are each to exercise its powers so as not to interfere with the free and full exercise of the powers of the other. It is clear that the federal government, when acting within a delegated power, may override countervailing state interests. As long ago as 1925, the court put to rest the contention that state concerns might constitutionally outweigh the importance of an otherwise valid federal statute regulating commerce. Nor is there any contrary authority in the reasoning of our cases imposing clear statement rules in some instances of legislation that would significantly alter the state-national balance. In the absence of a clear statement of congressional design, for example, we have refused to interpret ambiguous federal statutes to limit fundamental state legislative prerogatives, our understanding being that such prerogatives, through which a state defines itself as a sovereign, are powers with which Congress does not readily interfere. Likewise, when faced with two plausible interpretations of a federal criminal statute, we generally will take the alternative that does not force us to impute an intention to Congress to use its full commerce power to regulate conduct traditionally and ably regulated by the states. These clear statement rules, however, are merely rules of statutory interpretation, to be relied upon only when terms of a statute allow, and in cases implicating Congress's historical reluctance to trench on state legislative prerogatives or to enter into spheres already occupied by the states. They are rules for determining intent when legislation leaves intent subject to question, but our hesitance to presume that Congress has acted to alter the state-federal status quo when presented with a plausible alternative has no relevance whatever to the inquiry whether it has the commerce power to do so, or to the standard of judicial review when Congress has definitely meant to exercise that power. Indeed, to allow our hesitance to affect the standard of review would inevitably degenerate into the sort of substantive policy review that the court found indefensible 60 years ago. The court does not assert, and could not plausibly maintain, that the commerce power is wholly devoid of congressional authority to speak on any subject of traditional state concern. But if congressional action is not forbidden absolutely when it touches such a subject, it will stand or fall depending on the court's view of the strength of the legislation's commercial justification. And here, once again, history raises its objections that the court's previous essays in overriding congressional policy choices under the Commerce Clause were ultimately seen to suffer two fatal weaknesses. When dealing with acts of Congress as distinct from state legislation subject to review under the theory of dormant commerce power, nothing in the clause compelled the judicial activism, and nothing about the judiciary as an institution made it a superior source of policy on the subject Congress dealt with. There is no reason to expect the lesson would be different another time. There remains questions about legislative findings. The Court of Appeals expressed the view that the result in this case might well have been different if Congress had made explicit findings that guns in schools have a substantial effect on interstate commerce, and the court today does not repudiate that position. Might a court, aided by such findings, have subjected this legislation to less exacting scrutiny? Or put another way, should a court have deferred to such findings if Congress had made them? The answer to either question must be no, although, as a general matter, findings are important and to be hoped for in the difficult cases. It is only natural to look for help with a hard job, and reviewing a claim that Congress has exceeded the commerce power is much harder in some cases than in others. A challenge to congressional regulation of interstate garbage hauling would be easy to resolve. Review of congressional regulation of gun possession in schoolyards is more difficult, both because the link to interstate commerce is less obvious and because of our initial ignorance of the relevant facts. In a case comparable to this one, we may have to dig hard to make a responsible judgment about what Congress could reasonably find, because the case may be close, and because judges tend not to be familiar with the facts that may or may not make it close. But while the ease of review may vary from case to case, it does not follow that the standard of review should vary, much less that explicit findings of fact would even directly address the standard. The question for the courts, as all agree, is not whether as a predicate to legislation Congress in fact found that a particular activity substantially affects interstate commerce. The legislation implies such a finding, and there is no reason to entertain claims that Congress acted ultra vires intentionally. Nor is the question whether Congress was correct in so finding. The only question is whether the legislative judgment is within the realm of reason. Congressional findings do not, however, directly address the question of reasonableness. They tell us what Congress actually has found, not what it could rationally find. If indeed the court were to make the existence of explicit congressional findings dispositive in some close or difficult cases, something other than rationality review would be afoot. The resulting congressional obligation to justify its policy choices on the merits would imply either a judicial authority to review the justification and hence the wisdom of those choices, or authority to require Congress to act with some high degree of deliberateness, of which express findings would be evidence. But review for congressional wisdom would just be the old judicial pretension discredited and abandoned in 1937, and review for deliberateness would be as patently unconstitutional as an act of Congress mandating long opinions from this court. Such a legislative process requirement would function merely as an excuse for covert review of the merits of legislation under standards never expressed and more or less arbitrarily applied. Under such a regime, in any case, the rationality standard of review would be a thing of the past. On the other hand, to say that courts applying the rationality standard may not defer to findings is not, of course, to say that findings are pointless. They may, in fact, have great value in telling courts what to look for, in establishing at least one frame of reference for review, and inciting to factual authority. The research underlying Justice Breyer's dissent was necessarily a major undertaking. Help is welcome, and it not incidentally shrinks the risk that judicial research will miss material scattered across the public domain or buried under pounds of legislative record. Congressional findings on a more particular plane than this record illustrates would accordingly have earned judicial thanks. But thanks do not carry the day, as long as rational possibility is the touchstone, and I would not allow for the possibility, as the court's opinion may, that the addition of congressional findings could in principle have affected the fate of the statute here. Because Justice Breyer's opinion demonstrates beyond any doubt that the act in question passes the rationality review that the court continues to espouse, today's decision may be seen as only a misstep, its reasoning and its suggestions not quite in gear with the prevailing standard, but hardly an epical case. I would not argue otherwise, but I would raise a caveat. Not every epical case has come in epical trappings. Jones and Laughlin did not reject the direct-indirect standard in so many words. It just said the relation of the regulated subject matter to commerce was direct enough. But we know what happened. I respectfully dissent. Justice Breyer, with whom Justice Stevens, Justice Souter, and Justice Ginsburg joined dissenting. The issue in this case is whether the Commerce Clause authorizes Congress to enact a statute that makes it a crime to possess a gun in or near a school. In my view, the statute falls well within the scope of the Commerce power, as this court has understood that power for over the last half-century. In reaching this conclusion, I apply three basic principles of Commerce Clause interpretation. First, the power to regulate commerce among the several states encompasses the power to regulate local activities insofar as they significantly affect interstate commerce. As the majority points out, the court, in describing how much of an effect the clause requires, sometimes has used the word substantial and sometimes has not. And as the majority also recognizes in quoting Justice Cardozo, the question of degree, how much effect, requires an estimate of the size of the effect that no verbal formulation can capture with precision. I use the word significant because the word substantial implies a somewhat narrower power than recent precedent suggests, but to speak of substantial effect rather than significant effect would make no difference in this case. Second, in determining whether a local activity will likely have a significant effect upon interstate commerce, a court must consider not the effect of an individual act, a single instance of gun possession, but rather the cumulative effect of all similar instances, i.e., the effect of all guns possessed in or near schools. As this court put the matter almost 50 years ago, it is not enough that the individual activity, when multiplied into a general practice, contains a threat to the interstate economy that requires preventative regulation. Third, the Constitution requires us to judge the connection between a regulated activity and interstate commerce, not directly, but at one remove. Courts must give Congress a degree of leeway in determining the existence of a significant factual connection between the regulated activity and interstate commerce, both because the Constitution delegates the commerce power directly to Congress and because the determination requires an empirical judgment of a kind that a legislature is more likely than a court to make with accuracy. The traditional words rational basis capture this leeway. Thus, the specific question before us, as the court recognizes, is not whether the regulated activity sufficiently affected interstate commerce, but rather whether Congress could have a rational basis for so concluding. I recognize that we must judge this matter independently. Simply because Congress may conclude that a particular activity substantially affects interstate commerce does not necessarily make it so. And I also recognize that Congress did not write specific interstate commerce findings into the law under which Lopez was convicted. Nonetheless, as I have already noted, the matter that we review independently, i.e. whether there is a rational basis, already has considerable leeway built into it. And the absence of findings at most deprives the statute of the benefit of some extra leeway. This extra deference in principle might change the result in a close case, though in practice it has not made a critical legal difference. It would seem particularly unfortunate to make the validity of a statute at hand turn on the presence or absence of findings. Because Congress did make findings, though not until after Lopez was prosecuted, doing so would appear to elevate form over substance. In addition, despite the Court of Appeals' suggestion to the contrary, there is no special need here for a clear indication of Congress's rationale. The statute does not interfere with the exercise of state or local authority. Moreover, any clear statement rule would apply only to determine Congress's intended result, not to clarify the source of its authority or measure the level of consideration that went into its decision. And here there is no doubt as to which activities Congress intended to regulate. Applying these principles to the case at hand, we must ask whether Congress could have had a rational basis for finding a significant or substantial connection between gun-related school violence and interstate commerce. Or, to put the question in the language of the explicit finding that Congress made when it amended this law in 1994, could Congress rationally have found that violent crime in school zones, through its effect on the quality of education, significantly or substantially affects interstate or foreign commerce? As long as one views the commerce connection not as a technical legal conception, but as a practical one, Swift and Covey, United States, the answer to this question must be a yes. Numerous reports and studies generated both inside and outside government make clear that Congress could reasonably have found the empirical connection that its law implicitly or explicitly asserts. For one thing, reports, hearings, and other readily available literature make clear that the problem of guns in and around schools is widespread and extremely serious. These materials report, for example, that 4% of American high school students and 6% of inner-city high school students carry a gun to school at least occasionally, that 12% of urban high school students have had guns fired at them, that 20% of those students have been threatened with guns, and that in any 6-month period, several 100,000 school children are victims of violent crimes in or near their schools. And they report that this widespread violence in schools throughout the nation significantly interferes with the quality of education in those schools. Based on reports such as these, Congress obviously could have thought that guns and learning are mutually exclusive. Congress could therefore have found a substantial educational problem, teachers unable to teach, students unable to learn, and concluded that guns near schools contribute substantially to the size and scope of that problem. Having found that guns in schools significantly undermine the quality of education in our nation's classrooms, Congress could also have found, given the effect of education upon interstate and foreign commerce, that gun-related violence in and around schools is a commercial as well as a human problem. Education, although far more than a matter of economics, has long been inextricably intertwined with the nation's economy. When this nation began, most workers received their education in the workplace, typically, like Benjamin Franklin, as apprentices. As late as the 1920s, many workers still received general education directly from their employers, from large corporations such as General Electric, Ford, and Goodyear, which created schools within their firms to help both the worker and the firm. As public school enrollment grew in the early 20th century, the need for industry to teach basic educational skills diminished, but the direct economic link between basic education and industrial productivity remained. Scholars estimate that nearly a quarter of America's economic growth in the early years of this century is traceable directly to increased schooling, and that the economic returns to this investment in education exceeded the returns to conventional capital investment. In recent years, the link between secondary education and business has strengthened, becoming both more direct and more important. Scholars on the subject report that technological changes and innovation in management techniques have altered the nature of the workplace, so that more jobs now demand greater educational skills. There is evidence that service, manufacturing, or construction jobs are being displaced by technology that requires a better educated worker, or, more likely, are being exported overseas. That workers with truly few skills by the year 2000 will find that only 1 job out of 10 will remain, and that, over the long haul, the best way to encourage the growth of high-wage jobs is to upgrade the skills of the workforce. Better trained workers become more productive workers, enabling a company to become more competitive and expand. Increasing global competition also has made primary and secondary education economically more important. The portion of the American economy attributable to international trade nearly tripled between 1950 and 1980, and more than 70% of American-made goods now compete with imports. Yet, lagging worker productivity has contributed to negative trade imbalances and to real hourly compensation that has fallen below wages in 10 other industrialized nations. At least some significant part of this serious productivity problem is attributable to students who emerge from classrooms without the reading or mathematical skills necessary to compete with their European or Asian counterparts, and presumably to high school dropout rates of 20 to 25%, up to 50% in inner cities. Indeed, Congress has said, when writing other statutes, that functionally or technologically illiterate Americans in the workforce erode our economic standing in the international marketplace, and that our nation is paying the price of scientific and technological illiteracy with our productivity declining, our industrial base ailing, and our global competitiveness dwindling. Finally, there is evidence that today, more than ever, many firms base their location decisions upon the presence or absence of a workforce with a basic education. In light of this increased importance of education to individual firms, it is no surprise that half of the nation's manufacturers have become involved with setting standards and shaping curricula for local schools, that 88% think this kind of involvement is important, that more than 20 states have recently passed educational reforms to attract new business, and that business magazines have begun to rank cities according to the quality of their schools. The economic links I have just sketched seem fairly obvious. Why, then, is it not equally obvious in light of those links that a widespread, serious, and substantial physical threat to teaching and learning also substantially threatens the commerce to which that teaching and learning is inextricably tied? That is to say, guns in the hands of 6% of inner-city high school students and gun-related violence throughout a city's schools must threaten the trade and commerce that those schools support. The only question then is whether the latter threat is, to use the majority's terminology, substantial. The evidence of 1. The extent of the gun-related violence problem, 2. The extent of the resulting negative effect on classroom learning, and 3. The extent of the consequent negative commercial effects when taken together indicate a threat to trade and commerce that is substantial. At the very least, Congress could rationally have concluded the links are substantial. Specifically, Congress could have found that gun-related violence near the classroom poses a serious economic threat, 1. to consequently inadequately educated workers who must endure low-paying jobs. As I have pointed out, Congress has written that the occurrence of violent crime in school zones has brought about a decline in the quality of education that has an adverse impact on interstate commerce and the foreign commerce of the United States. The violent-related facts, the educational facts, and the economic facts taken together make this conclusion rational. And because under our case law, the sufficiency of the constitutionally necessary Commerce Clause link between a crime of violence and interstate commerce turns simply upon size or degree, those same facts make the statute constitutional. To hold the statute constitutional is not to obliterate the distinction between what is national and what is local, nor is it to hold that the Commerce Clause permits the federal government to regulate any activity that it found was related to the economic productivity of individual citizens, to regulate marriage, divorce, and child custody, or to regulate any and all aspects of education. First, this statute is aimed at curbing a particularly acute threat to the educational process: the possession and use of life-threatening firearms in or near the classroom. The empirical evidence that I have discussed above unmistakably documents the special way in which guns and education are incompatible. This court has previously recognized the singularly disruptive potential on interstate commerce that acts of violence may have. Second, the immediacy of the connection between education and the national economic well-being is documented by scholars and accepted by society at large in a way and to a degree that may not hold true for other social institutions. It must surely be the rare case, then, that a statute strikes at conduct that, when considered in the abstract, seems so removed from commerce, but which, practically speaking, has so significant an impact upon commerce. In sum, a holding that the particular statute before us falls within the commerce power would not expand the scope of that clause. Rather, it simply would apply pre-existing law to changing economic circumstances. It would recognize that in today's economic world, gun-related violence near the classroom makes a significant difference to our economic as well as our social well-being. In accordance with well-accepted precedent, such a holding would permit Congress to act in terms of economic realities, would interpret the commerce power as an affirmative power commensurate with the national needs, and would acknowledge that the Commerce Clause does not operate so as to render the nation powerless to defend itself against economic forces that Congress decrees inimical or destructive of the national economy. The majority's holding that Section 922 falls outside the scope of the Commerce Clause creates three serious legal problems. First, the majority's holding runs contrary to modern Supreme Court cases that have upheld congressional actions despite connections to interstate or foreign commerce that are less significant than the effect of school violence. In Perez v. United States, the court held that the Commerce Clause authorized a federal statute that makes it a crime to engage in loan sharking, extortionate credit transactions, at a local level. The court said that Congress may judge that such transactions, though purely intrastate, affect interstate commerce. Presumably, Congress reasoned that threatening or using force, say with a gun on a street corner to collect a debt, occurs sufficiently often so that the activity by helping organized crime affects commerce among the states. But why then cannot Congress also reason that the threat or use of force, the frequent consequence of possessing a gun in or near a school, occurs sufficiently often so that such activity, by inhibiting basic education, affects commerce among the states? The negative impact upon the national economy of an inability to teach basic skills seems no smaller nor less significant than that of organized crime. In Kassenbach v. McClung, this court upheld, as within the commerce power, a statute prohibiting racial discrimination at local restaurants, in part because that discrimination discouraged travel by African Americans and in part because that discrimination affected purchases of food and restaurant supplies from other states. In Daniel v. Paul, this court found an effect on commerce caused by an amusement park located several miles down a country road in the middle of Alabama, because some customers, the court assumed, some food, 15 paddle boats, and a jukebox had come from out of state. In both of these cases, the court understood that the specific instance of discrimination at a local place of accommodation was part of a general practice that, considered as a whole, caused not only the most serious human and social harm, but had nationally significant economic dimensions as well. It is difficult to distinguish the case before us, for the same critical elements are present. Businesses are less likely to locate in communities where violence plagues the classroom. Families will hesitate to move in neighborhoods where students carry guns instead of books. Congress expressly found in 1994 that parents may decline to send their children to school in certain areas due to concern about violent crime and gun violence. And, to look at the matter in the most narrowly commercial manner, interstate publishers, therefore, will sell fewer books and other firms will sell fewer school supplies, where the threat of violence disrupts learning. Most importantly, like the local racial discrimination at issue in McClung and Daniel, the local instances here, together and considered as a whole, create a problem that causes serious human and social harm, but also has nationally significant economic dimensions. In Wickard v. Filburn, this court sustained the application of the Agricultural Adjustment Act of 1938 to wheat that Filburn grew and consumed on his own local farm because, considered in its totality, 1. Homegrown wheat may be induced by rising prices to flow into the market and check price increases, and 2. Even if it never actually enters the market, homegrown wheat nonetheless supplies the need of the man who grew it, which would otherwise be reflected by purchases in the open market, and in that sense competes with wheat in commerce. To find both of these effects on commerce significant in amount, the court had to give Congress the benefit of the doubt. Why would the court, to find a significant or substantial effect here, have to give Congress any greater leeway? The second legal problem the court creates comes from its apparent belief that it can reconcile its holding with earlier cases by making a critical distinction between commercial and non-commercial transactions. That is to say, the court believes the Constitution would distinguish between two local activities, each of which has an identical effect upon interstate commerce, if one, but not the other, is commercial in nature. As a general matter, this approach fails to heed this court's earlier warning not to turn questions of the power of Congress upon formulas that would give controlling force to nomenclature, such as production and indirect, and foreclose consideration of the actual effects of the activity in question upon interstate commerce. Moreover, the majority's test is not consistent with what the court saw as the point of the cases that the majority now characterizes. Although the majority today attempts to categorize Perez, McClung, and Wickard as involving intrastate economic activity, The courts that decided each of those cases did not focus upon the economic nature of the activity regulated. Rather, they focused upon whether that activity affected interstate or foreign commerce. In fact, the Wickard court expressly held that Filburn's consumption of homegrown wheat, though it may not be regarded as commerce, could nevertheless be regulated, whatever its nature, so long as it exerts a substantial economic effect on interstate commerce. More importantly, if a distinction between commercial and non-commercial activities is to be made, this is not the case in which to make it. The majority clearly cannot intend such a distraction to focus narrowly on an act of gun possession standing by itself, for such a reading could not be reconciled with either the civil rights cases, McClung and Daniel, or Perez, and in each of those cases, the specific transaction, the race-based exclusion, the use of force, was not itself commercial. And if the majority instead means to distinguish generally among broad categories of activities, differentiating what is educational from what is commercial, then as a practical matter, the line becomes almost impossible to draw. Schools that teach reading, writing, mathematics, and related basic skills serve both social and commercial purposes, and one cannot easily separate the one from the other. American industry itself has been and is again involved in teaching. When and to what extent does its involvement make education commercial? Does the number of vocational classes that train students directly for jobs make a difference? Does it matter if the school is public or private, nonprofit or profit-seeking? Does it matter if a city or state adopts a voucher plan that pays private firms to run a school? Even if one were to ignore these practical questions, why should there be a theoretical distinction between education when it significantly benefits commerce and environmental pollution when it causes economic harm? Regardless, if there is a principal distinction that could work both here and in future cases, Congress, even in the absence of vocational classes, industry involvement, and private management, could rationally conclude that schools fall on the commercial side of the line. In 1990, the year Congress enacted the statute before us, primary and secondary schools spent $230 billion. That is, nearly $250 billion, which accounts for a significant portion of our $5.5 trillion gross domestic product for that year. The business of schooling requires expenditure of these funds on student transportation, food and custodial services, books, and teacher salaries. These expenditures enable schools to provide a valuable service, namely to equip students with the skills they need to survive in life and more specifically in the workplace. Certainly, Congress has often analyzed school expenditure as if it were a commercial investment, closely analyzing whether schools are efficient, whether they justify the significant resources they spend, and whether they can be restructured to achieve greater returns. Why could Congress, for Commerce Clause purposes, not consider schools as roughly analogous to commercial investments from which the nation derives the benefit of an educated workforce? The third legal problem created by the court's holding is that it threatens legal uncertainty in an area of law that, until this case, seemed reasonably well settled. Congress has enacted many statutes, more than 100 sections of the United States Code, including criminal statutes, at least 25 sections, that use the words affecting commerce to define their scope, and other statutes that contain no jurisdictional language at all. Do these or similar statutes regulate non-commercial activities? If so, would that alter the meaning of affecting commerce in a jurisdictional element? More importantly, in the absence of a jurisdictional element, are the courts nevertheless to take Wickard and later similar cases as inapplicable and to judge the effect of a single non-commercial activity on interstate commerce without considering similar instances of the forbidden conduct? However these questions are eventually resolved, the legal uncertainty now created will restrict Congress's ability to enact criminal laws aimed at criminal behavior that, considered problem by problem rather than instance by instance, seriously threatens the economic as well as social well-being of Americans. In sum, to find this legislation within the scope of the Commerce Clause would permit Congress to act in terms of economic realities. It would interpret the clause as this court has traditionally interpreted it, with the exception of one wrong turn subsequently corrected. Upholding this legislation would do no more then simply recognize that Congress had a rational basis for finding a significant connection between guns in or near schools, and through their effect on education, the interstate and foreign commerce they threaten. For these reasons, I would reverse the judgment of the Court of Appeals. Respectfully, I dissent. For more audio cases, visit us at laudioforlisteners.com. Follow us on Instagram and Facebook, and subscribe to our YouTube channel.